We're live, I believe. So, good morning, everyone. I apologise for Ollie's Christmas hat. Welcome to this Archer Advent calendar. We're going to obviously go through 24 issues that have occurred during the year. There are some case law. There is some statute. There are some things that have just occurred of consequence throughout the year. Ollie's doing most of the law. I'm doing most of the funny bits. You may disagree with that by the end. We get some appearances from Mark Morrison, James Bond, and a bit of singing at the end. So without further ado, I shall pass you over to Ollie. So if you don't know who we are, by the way, I'm Andrew Rush. I'm the senior partner of Archer. Ollie is another partner at Archer. He's the one with all the legal knowledge, and he's going to start with the proper slides.
Indeed, yeah. Good morning, everyone. So the theme of the seminars this morning is the other. So we're going to try and get through 24 different things. Whether we can achieve that in a time or not, we'll have to wait and see. Some of them have more detail than others, and I will warn you from the start. Some of them involve Andrew singing, and some of them involve a bit of self-promotion. This first one, window number one, is exactly that type of thing. So we're pleased to say that once again this year, Archer has ranked top tier in Legal 500 and top tier in the Chambers. These are two legal directories, if you don't know. So they're compiled by an independent-ish company that likes to go out and speak to the market, speaks to our referees, our nice clients and contacts and things, who thankfully rated us very highly. So it's us, Mills and Reeve and Eversheds are the top ranked in Chambers and Legal 500 in East Anglia. And we will come on to discuss later how that impacts us nationwide. So on to some proper now, and we're going to talk about a recent case, Henry and Ali Fix, which was actually an Archer case run by Hannah. Now this is one of the first cases one of the most recent cases to talk about the interplay between smash and grab and true valuation disputes. Smash and grabs being those procedural ones where someone hasn't served a payment notice or a payless notice, and a true value being a substantive one, what's actually due either way. So in this case, Henry was the employer, Ali Fix was the subcontractor. The final date of payment of an interim payment was the 13th of December 2022, and Ali Fix commenced a smash and grab on the 25th of December. I'm not sure that might be the right date, 25th, but anyway, certainly around Christmas time, saying that Henry had failed to serve the right payless notices. In response, Henry, during the course of that adjudication, started its own true value dispute, because although it said it did serve payless notices, it wanted to protect its position in the event that was found to be wrong. The smash and grab decision eventually came on the 27th of January, and at that point, the adjudicator in the true value dispute, Matt Malloy, who's a well-known adjudicator, stayed the true value adjudication. And the reason for that was the case law recently has become quite clear that when you've had a smash and grab against you, you must pay that before you can continue with a true value dispute. So Henry, having failed in its defence of the smash and grab, it paid the smash and grab as it was required to, at which point the true value adjudication recommenced and resulted in a decision on the 6th of March this year. And the net effect of that was that around £200,000 was decided to be due back from Ali Fix to Henry. So Henry went to court to try and enforce that award, as it would normally do, and Ali Fix said no, because at the final date of payments on the 13th of December, the smash and grab was unpaid, there was never any jurisdiction for the adjudicator to hear the true value one. And the court said that was right. And the reason for that was precisely because when the adjudication was commenced, the true value adjudication commenced on the 18th of January, as a matter of law, the outstanding payment was outstanding because no payless notice had been served. So even though Henry believed it had a genuine defence to the smash and grab, and even though it paid the decision in the smash and grab within a few days, accepting, although not perhaps agreeing with the decision, accepting it was binding, it still meant that the adjudicator, Matt Malloy, had no jurisdiction ever. So we were quite surprised with the outcome, and I think it certainly brings in quite a lot of uncertainty. The court did say that this shouldn't prevent people from ever starting a true value adjudication when there is a smash and grab in the offing. But in reality, the likelihood is that an adjudicator asked to sit over a true value adjudication when there is an ongoing smash and grab, or even potentially the threat of a smash and grab, it will be difficult for an adjudicator to accept jurisdiction because of the risk that ultimately it turns out that the smash and grab is correct. Quite how we'll see this going forward, we'll have to wait and see, but it does seem to make it much harder to start a true value adjudication where there is the potential for a no payment notice, no pay less notice type adjudication. And very recently, only a few days ago, a case called Little and 3CL, which is a different Little and 3CL case to the one that most people have heard about, came out. This was solely looking at again, the same question about the interplay between a smash and grab and a true value adjudication. And I won't go through it in detail, but effectively it seems to say, yes, the decision in Henry and Ali Fix was correct. And second, not only can a true value dispute not be commenced, but potentially a wider range of disputes can't be commenced. So the court said that if at the date of a payless notice, when a payless notice could have been put in, a dispute could have been listed on that, and it's not because of the failure to put the payless notice in, an adjudication on that can't be brought either. So not just a true valuation dispute asking for the date, asking for a valuation of works at a particular date, but any dispute which could have been included in a payless notice. The obvious example is a claim for repayment of LADs, which may have arisen at the date a payless notice could be put in. If it wasn't, and there's a smash and grab adjudication in the offing or ongoing, the court says that you can't start a dispute about that either. So the upshot of this really seems to be the court is putting procedural issues, smash and grabs, and the need to get payment notices and payless notices in very highly indeed. There's obviously an easy way to deal with this, which is to get your payment notices in. It wouldn't be Christmas if we didn't say that. But ultimately, if you don't do so and the other party raises an adjudication against you, it's going to be very difficult to avoid and take strategies to mitigate the exposure there. So that's window number 2. On to window number 3. Less of a legal issue, more of a tax and accountancy issue. But this is one which is coming up in April next year. There are changes to the construction industry scheme. If you don't know what the construction industry scheme is, it's basically a tax scheme which ensures that HMRC gets paid and takes the burden away from subcontractors and subcontractors onto contractors. It's not massively popular amongst contractors because it's complicated to administer, and it's not massively popular amongst subcontractors either because they lose the ability to control their cash flow because effectively they get the tax deducted before it comes to them. So it's common for most large subcontractors or subcontractors of any size to apply for gross payment status, which means that effectively the CIS doesn't apply and you get paid the tax and deal with that yourself. The change from April is that HMRC is going to have more stringent requirements to register for gross payment status. So as well as the existing requirements, which are the turnover threshold and such like, there will be a requirement to demonstrate compliance with other tax obligations and also to make sure that HMRC can immediately revoke gross payment status if it considers there's a risk of tax fraud and that kind of thing. So we're not tax lawyers, but ultimately if you have involvement with the CIS scheme, whether as a contractor or a subcontractor, you need to be aware of these changes coming up and just consider whether come April next year, they're going to affect how you're being paid. And window number 4 is HS2. This is a very brief one, and it's just a big hole in the ground. Really just an excuse to put this picture in. So this is next to Euston Station. I suppose the news this year in HS2 was the cancellation of the Manchester leg. And the news next year is, well, who knows what's going to happen. In terms of construction law, nothing's changed. If you've got a contract and you're working on HS2, you need to carry on with these things, but certainly one to keep an eye on as the next year progresses, because you'd be a brave man to bet what's going to happen next on this one, I think. And on to window number 5, which is Andrew. I'm afraid some singing.
Well, I'm not sure this is singing. This is more just, this is rack, or in the words of Mark Morrison, rack. Come on, guys, turn on the rack. The turn of the reinforced autoclaved aerated concrete. Right. So, what is RAC? Well, RAC is, well, that's Mark Morrison. RAC is reinforced autoclaved aerated concrete. What's the problem? Well, you'll all be aware of what RAC is, the problem it's causing, in that it's typically in schools. It's been shown to be, at least in part, dangerous, and therefore there is a problem. We have to deal with it. What is RAC? Well, I'm as you can tell, I used to be an engineer, but I don't profess to be one anymore. It's lightweight concrete. It's essentially a sort of an aero bar type concrete. It's got very low levels of reinforcement in. It was meant to be lightweight, easy to use, typically used in planks, typically used to support, act as a ceiling type floor. The problem is that the span to depth ratios aren't enough, so effectively it wouldn't meet current standards. There's insufficient reinforcement, and it can lead to a catastrophic failure. Catastrophic failure basically is a failure which just occurs when you don't know it's coming. And the picture is an example of one in a school where that did fail. So, that is a problem in the market. What's the solution? It's difficult. Talking to the market, you're getting some contractors who are bidding to do temporary work, some are bidding to do permanent works. There doesn't seem to be any obvious long-term temporary solution that it needs to be replaced. And it does smack a bit of the initial view of cladding, a bit of a chaos. Some are doing temporary work, some are doing permanent. Every cloud has a silver lining. This is creating a certain amount of work. So, I think over the next year or so, there may be a clearer picture of what we're doing with RAC. And also less singing, probably. The next one, Building Safety Act. Now, I'm going to talk about the Building Safety Act on 3 occasions during this talk. The first point really is just to say it's come into effect. The Building Safety Act was actually 2022. That was the enabling legislation. It's a bit like the Health and Safety at Work Act. That's the overriding legislation, and underneath that is all the sort of secondary legislation that has all the detail in it. I've just listed a few up there. There are lots of different pieces of legislation. It's quite complicated. And the primary issue is it relates to higher risk buildings. So there's a bit of a misnomer here because it talks about HRBs. Everyone thinks that's high-rise buildings if you're not involved with it. I mean, it's arguably the same thing. Higher risk buildings. What we did learn into 2023 was what exactly a higher risk building was going to be. So after lots of consultation, it's confirmed as 18 meters in height or 7 stories, or at least 7 stories, and it has to contain at least 2 residential units. So it's aimed at basically blocks of flats. It also covers care homes and hospitals because they are buildings that have higher fire issues. They are treated slightly differently post completion. And the bottom line is really it's all about high-rise residential flats. What about, so somebody might say, well, okay, I live in one already. What about those ones? What's going to happen to those ones? Because all the legislation is about building new buildings. What about fixing the defective ones that already exist? And what happened during the year was that Michael Gove basically made all the developers sign the developer's pledge, which subsequently led on to each developer signing a developer remediation contract. Now, the developer's pledge was effectively a document where each developer who's built these blocks of flats that need to be fixed has promised to fix them. And the reason they all signed that willingly and without any fuss was because Michael Gove said, if you don't sign it, you won't get building control on any other jobs you may subsequently want to use or subsequently want to build. I'm just flicking through my music for the next one. What should happen is there is a bit of clarity as to what's meant by the Building Safety Act. It's constantly evolving, so that is something that's going to keep going into 2024 and arguably 2025. And we have got a whole wave of buildings basically being repaired by the original developers. Here is a list of the 53 developers who signed the developer's pledge. There are very few large blocks of flats that aren't covered by one of those. Quite how quickly they'll get fixed and who'll ultimately end up paying for it, I think is still to be decided. My next slide is the bond market. Now, what you'll be asking yourself, perhaps more than anything else, is who is the next Bond? Could it be Daniel Craig staying on? Could it be Sean Connery coming back from the dead? Could it be this guy? I forget his name.
Yes, Brother?
Or could it be these two? Well, who knows? But you couldn't not do that with this. You'd have to go the older version or the younger version. Right, the actual bond market. That, by the way, is a picture of Carolyn. If you don't know, she's known as the cyborg in the office, so she's much more likely to be Bond than anyone else anyway. What happened with the bond market? Well, it's been very difficult to get bonds. Insolvencies, particularly some high publicity type insolvencies, have caused an issue with the bonds. I'll come on to those later. What it's led to is high price increases with bonds, and certain contractors finding it very difficult. What it also has led to is it's amended the terms of bonds. So typically now the bond expires at practical completion. And the reason for that is that any contractor has a certain size bond pot. If any of the bonds they've got drag on for another year, it prevents them from getting another bond on a new job. So what the market has recognized is the bond probably needs to expire at PC. It causes its own problems during the defects period, but the primary reason for a bond is to deal with an insolvency during the works. So it's less of an issue post-PC. It has also led to parties coming up with alternative solutions to deal with the lack of bonds. So, for example, escrow agreements are more popular, direct appointments between employer and subcontractor or contractor and supplier becoming more common, direct payment agreements becoming more common, and in fact, a whole combination of all of those. So the bond market has had a knock-on effect. My final slide, I believe, is it for the next?
For now,
is insolvencies. Now, insolvency is obviously a constant problem for everyone. Where are we in the market cycle? Well, 2023 saw a particular rise in insolvencies. Now, that chart is actually quite helpful. The blue is the overall figure. Green and red are basically main contractors are red, green is subcontractors, yellow is civil engineering. Now, what you can see from that is that the civil engineering guys haven't really had an insolvency issue. And actually, there's been quite a lot of work for civil engineering contractors. What we've seen in the market is typically the 50 to 100 million turnover contractor is the one that struggled most. They're the ones involved in building, not civils. And they struggle most typically because of material price increases, market labor shortages, and those size contractors are the ones who don't have the balance sheet to cope, but are doing big enough jobs to suffer quite heavily when a problem occurs. That said, the two biggest insolvencies occurred with Buckingham Group and Henry Construction. Neither of those fit into the above category. Buckingham Group turning over 750 million, Henry approaching 400 million. Henry in particular had a big effect on the bond market. So what's the knock-on effect of the insolvencies? Well, anecdotally, there does seem to be a slight move back to tier one. And by that, there was a wave when Carillion went bust that people worried about the solvency of tier one contractors. Now it seems to be that actually, there's comfort in size. So tier one contractors seem to be slightly more popular maybe than were they before. People going bust leads to price increases because there's less supply chain. The contractor taking on a job hasn't got as much competition. So there's a price increase that flows from insolvency. It takes its time to come through the system, but it does. And what it also has led legally to is a sort of alternative approach to procurement, particularly to finish those jobs that halfway through or have just started with an insolvent contractor. And it's led to an increase in trade contracting, which is my segue to Ollie to talk about trade contracting.
Almost like it's planned.
Yes.
I'm disappointed you didn't do the knock-knock joke, though. Right, trade contracting, what is it? So this helpful diagram basically sets out the structure of how this works. So the employer employs the trade contractors directly. also employs a construction manager who oversees the trade contracts on the employer's behalf. And the employer also appoints the various consultants. So you'll see effectively the employer retains a high degree of control sitting in the middle. And why is it used? Well, as Andrew just said, probably the main issue, or the main reason at the moment, is because it helps to guard against insolvency. The client stays in the centre of things. They're not reliant on a single main contractor. So, for example, Buckingham or Henry, they're not at the risk of that party going insolvent and leaving the project in distress. And it also allows the client to specify and appoint their preferred subcontractors again without having to run things through a main contractor. One thing which has been suggested is it's slightly less adversarial than a traditional contracting as well, because you've not got the main contractor and that relationship, everything going through them. Not sure that's entirely correct, but I suppose we can wait to see. But the reason we mention it as a 2023 thing is precisely as Andrew says, because of the insolvencies and the risk of insolvencies, more clients are seeking to use this as a procurement route. Is that a fair summary, Andrew?
Yeah, and one of the biggest issues is take a Henry job. The contractor coming onto that job doesn't want to take the risk for what's been done before, and won't enter into a main contract taking that risk. So that contractor coming on board will want to manage the trade contractors, but won't take overall responsibility. So it's a way of getting around that problem of someone taking over a big job from someone else.
Half-finished jobs. Yeah, indeed. Okay, right. Another case now, ISG and FK Construction. So this was on the back of a very large smash and grab. You'll see there that there was a £1.691 million payment ordered from ISG to FK in February this year. So that was purely because ISG failed to get the payment notices in and pay us notices in. So a very costly mistake. When it came to enforcement by FK Construction, ISG raised two issues. One was a adjudication they had on a later payment cycle, which showed that the true value of the works was actually £900,000 less. And the second was a different project where ISG and FK were also working together, called Project Triathlon. There were various adjudications on that one, and the net effect was that on Project Triathlon, FK owed ISG £66,000. So when it came to enforcement of the £1.6 million adjudication decision, ISG tried to say, well, we can't pay you that sum because it would be unfair. First, because of the £900,000 adjudication on the same project, and second, because of the £66,000 due to them on Project Triathlon. And the court basically said no. So there's some quite technical rules about when set-off of adjudication decisions can take place. And effectively, you need to have separate proceedings before the court, and also they all need to be in separate enforceable adjudication decisions. Now, the reason here was quite a technical one, which was basically that the separate proceedings hadn't been issued. So therefore, ISG was jumping the gun by trying to bring these separate decisions into play on the £1.6 million smash and grab enforcement. But really, this case is just another example of the technicalities involved in all these things. It's a very procedural area of law, because no one was disputing that the sum ultimately due to ISG was probably less than the 1.6 ordered. But it all became quite technical about the order of payments, which adjudications happen when, and about which proceedings could be offsetting each other. So again, it comes back to making sure you get your payment notices in the first place, because if they'd done that, ISG wouldn't have had this problem in the first place. But then also, once you've found yourself with a difficulty, you need to think very carefully about the procedure and the best way forward to try and mitigate exposure. Another case next, which is J&B Hopkins and A&V Building Solutions Limited. Another true value and payment dispute. So a bit of a saga, this one. There was a true value adjudication in November, which A&V were ordered £138,000 on in relation to their interim application 14. While that true value adjudication was ongoing, J&B started Part 8 proceedings, which are court proceedings, which are effectively to decide a dispute where there's no factual dispute, so questions of law. And the court said that interim application 14, which is the one the true value was being heard on was an invalid application because it was issued 1 day late. In the meantime, A&V had been awarded the £138,000 in that adjudication. So A&V had a decision to make. They started to enforce the true value, and then because of the Part 8 proceedings, which effectively said that there was no valid application, they instead went to appeal the Part 8 judgment. In the meantime, a separate adjudication had taken place, which had decided that rather than A&V being awarded £138,000, JMB in fact owed £83,000. So in the scheme of things, these numbers aren't massive. I suspect the legal costs on the Part 8 proceedings and everything would have been at least close to, if not in excess of the ultimate sums. And by the time that this decision actually came through, as I say, the final account adjudication had taken place and it became slightly academic. So the court did say, and the parties needed to seriously think about whether this was the right thing for them to do and try to discourage other people doing it. But the relevant to the Court of Appeal case about condition precedents. So, as is not uncommon, this was a case that was decided on a payment schedule and a set of amendments to that. So, in clause 9 of the main terms, you had these words: it's a condition precedent to payment that the subcontractor shall make monthly applications, and that the payment shall be in accordance with Appendix 6. Appendix 6 was the payment schedule, which had various columns, as I'm sure you all have seen. And in column A, it said the date which subcontractors to issue application to J and B was. And the various dates there were always 10 days before the valuation dates in column B, which was the last date in each calendar month. So a regular pattern there. And it's worth saying as well that these were based on J and B's standard terms. So clause 9.2 and 9.3 were unamended, and the payment schedule in Appendix 6 was an amended thing specific to this job. In particular, the words, which are at the bottom of this slide, if applications are not received from the subcontractor 7 days prior to the valuation date, then the subcontractor shall not be entitled to any payment. So the court was asked to look at the apparent discrepancy between the column A schedules, which had 10 days, and the 7 days in the last wording. And it said that the wording for the avoidance of doubt trumped what was in the column. And the reason for that was because it was bespoke to this project. So effectively, the Court of Appeal overturned the original decision, which said the payment application was 1 day late, because the difference between 7 days and 10 days is 3 days. And therefore, rather than being 1 day late, it was 2 days in time. And therefore, the application was valid. So a relatively fact-specific decision in the end, but really pointing to, the fact that where you have payment applications and payment schedules, there's often a conflict between the main contract, so clause 9 in this case, and the schedules, and they can get very difficult, particularly where terminology is often used flexibly, things like valuation date or due date or application date. It can get very complicated. The real lesson here is to be clear that all the payment provisions that you seek to negotiate during a contract tie up with what's in the standard term to hopefully avoid these kind of confusions happening later. Back to Andrew with a new hat.
New hat, I've got another one. Right. COVID Ukraine amendments. So what we saw in 2022 was, obviously COVID is well, I say it's on its way out. We have to be slightly careful about that. Ukraine is ongoing. Ukraine is still ongoing. So the point really here is what's happened with the contracts, where have the contracts moved to. So taking each one separately, COVID-19, it's probably safe to say now at the moment, COVID-19 is typically excluded as a relevant event or a compensation event. So you no longer have any right if anything is delayed as a result of COVID. There are some sort of halfway houses that say you're entitled to time only if the government has a formal lockdown, which they never did in the first case, or if the rules imposed are greater than the current CIC rules. But in truth, COVID-19, there is no relief effectively now. That's moved on. Whether that's too soon or not, and whether we'll have like a COVID-21 something, time will tell. on Ukraine, which effectively had a massive impact on material prices, certainly in certain areas. The market, as it normally does, has found alternative markets. Ukraine is obviously still ongoing, maybe isn't in the news as much as it should do because of Gaza, which I'll come on to in a moment. So is it any longer an issue? It probably still is, but the price increase, to the extent there's been a price increase, has probably already taken effect. But, you know, this is an example of something that may in 2024 come back again. And what we're seeing is, I'll come on to fluctuations, but what we're seeing is that in truth, the contracts never really did allow for price and material increases. If we're being honest, they dealt with it another way. Before I come on to the fluctuations, it's just worth thinking what the next force majeure event may be. You know, just doing the slide in the wrong order, force majeure is actually equivalent to impossibility. I put this time to be redefined by JCT without knowing that Ollie's about to do a slide on JCT 2024 that suggests it may be redefined by JCT. I think force majeure, as we now understand it, you know, everyone assumes it involves a pandemic. There was an awful lot of question marks about whether it did or didn't. Hopefully JCT will try and crystallize exactly what is meant by these events. Obviously, I don't know what the next force majeure event is any more than anyone else, but there's every chance that Gaza will affect oil prices, fuel prices. What is true to say is most contracts are not allowing any relief for those type of events, which brings me on to fluctuations. Fluctuations is a very non-helpful word. It's basically the expression used in JCT to deal with material and labor cost increases. It's not used in NEC. NEC refers to price inflation, which makes a lot more sense. JCT has different types of fluctuations as A, B, and C. And in practice, if you're under a fixed price contract and you have fluctuations or price inflation, then you can get additional payment if there has been significant material or labor increases, typically set against relevant indices, depending on what you might be using on your contract. The problem is that they were very rarely adopted. So you didn't get material labor price increases even during the sort of the worst of it. So we're not in that situation at the moment. So the current sets of amendments don't allow for price increases. What happened in 2023, at the start of the year, what we saw with jobs was that developers in particular were contracting with the supply chain and entering into effectively pre-main contract agreements where the supply chain were buying the materials under pre-construction services agreements, letters of intent, or doing the same with the main contractor. So effectively what they were doing was buying the material at the time to avoid the price increase that may occur during the year. That again seems to have stopped. There's much less sort of negotiation with specialist subcontractors at an early stage. It's gone back to the old traditional way. The question, I think, for 2024 is, you know, has the market peaked? Has the material price increase, labor increase peaked? Or is there an element of complacency here where everyone thinks it's gone away and it hasn't? And I think we'll have to see what happens in 2024. A bit of self-promotion. We were included as one of the Times best law firms for construction. I have to genuinely say, when the email came through, I thought it was a scam because there was a link to it. And I then pressed Sophos, this must be a scam. But actually, it's a nice award to be part of because you're voted by other law firms, not by, you know, your best mates who say how good you are. These are other law firms saying, we know what we're doing. And these are the other 13 law firms who make up the 14 top construction law firms in the Times. I don't know what their turnover and profit is, but I'm pretty certain it's a lot more than ours. They're of a size which makes it all the more rewarding that we get put in the same bracket. Ollie's really upset by that photograph because there's puddles in front of us. But there were 6 founding partners. We now have a team of 18 and we're still growing. Why us? Well, hopefully we give the service people want, and we don't have the London overhead. We know what we're doing, and we're delighted to be stuck in the same bracket as most of those big law firms on the other page. My final one for the moment is Part L that occurred during the year. Now, Part L was a change to the building regulations that effectively, although it came into effect in June, that it was introduced in June, it came into effect June 2023. And the idea was to improve the energy efficiency of homes. And again, it's all very laudable. I'm not saying it's not worth it, but I think the market was doing it anyway. But what it did do is it allowed developers, if they had a housing start by June 2023, to use the old regulations and not the new. So what did the house builders do? Well, they went and laid lots of foundations for lots of units without necessarily planning to put the actual structure on top for some time. I'm not criticizing the housing market for doing that, because that's just sensible business. But it did lead to an increase in what you might call the foundation sets of materials. Ground workers were really busy, but what's happened since, and I've spoken to a number of ground workers, is that they've had a lull in the work because all their work came at once. And until the house builders are building new foundations on the new regulations, the work's dried up to a certain extent. Fundamentally, the change to Part L regulations is a long-term improvement of environmental standards, basically with housing. But I would say, as I said earlier, construction industry gets lots of criticism, but actually it was moving towards that and has been for years, getting more and more efficient. So it's probably just regulating that. I think this is now Ollie.
Yeah. Right, now I'm not saying we found it difficult to find 24 interesting things to talk about, but this one is probably the bottom of the barrel: planning control orders. So there was a consultation this year, hence why we can include our 2023 roundup, which was the government looking at extending permitted development rights. So the first was to extend or remove the cap on the maximum amount of square footage that you can change to residential under existing PDRs. And the second potential change is a new PDR altogether to allow a change from hotel use to residential use. And this is all part of the government's drive to increase house building. We've not yet got a response from the government on this, but it's hopefully expected early in the next year. And I would expect to see these changes followed through at some point in 2024. So one to keep an eye out on. Now, Lidl and 3CL. So yeah, same parties as the mentioned earlier, but this was the earlier decision back in, I think, August or September, and it's the one which has got quite a bit of press during the year. So I won't go into the background of the case. It's a fairly typical construction dispute, but there were 4 big issues which came out of this judgment. And if you're into reading construction case law, this is probably one that's well worth a read, because it does cover a lot of issues which frequently come up in disputes, adjudications, and things we deal with on a day-to-day basis. So all very relevant. So the 4 main points I wanted to discuss really were, as on the slide. The first, LADs deducted in the payment notice. So Lidl's payment notice set out various deductions from milestone payments due to 3CL, and also sought to deduct LADs in the same notice. And the court said you couldn't do that. Effectively, there was a payment notice, which is to value the works, and a pay less notice to revalue the works if you missed the first chance, and to take off other items. And it looked at what was in the contract, what was to be allowed as part of valuation of the works, and that did not include LADs. And that's also true. This was a bespoke term, but also true of JCT provisions as standard. They don't typically allow payment certificates to include deductions for LADs. So the court said, because effectively the Lidl had tried to create a hybrid payment and pay less notice, that was invalid. And it drew a comparison with the law prior to the changes which took place in 2011, where we had the old withholding notice regime. And it said in the old regime, it would have been fine to include all within one withholding notice and then move on from there. But clearly the intention of the new regime was to have a payment notice and a separate payless notice, and you couldn't just morph the two. So this all comes back to fairly sort of well-trodden case law about substance, form and intent about noticing these things. But ultimately it's making clear that when you're serving a payment notice, you need to have regard to what's in the contract and what you're actually allowed to be value in there, and making sure you don't muddle the two. Because the risk is if you do muddle the two, you'll end up with a smash and grab against you and a potential payment of a very significant sum. So that's the first big point. The second point about conditions precedent. So there was in the standard provisions of the contract various requirements to serve applications with certain supporting information, and it was argued that they were a condition precedent to there being a valid application. And that was relevant, of course, because if there was no valid application, then the smash and grab based on there being an invalid payment notice would have failed. But the court looked at the things here, looked at the various provisions around conditions precedent and said, on the specific facts of this case, there was no condition precedent. And of relevance for general practitioners is the fact that the payment certificate, the terms required to the application must have in certain information with them. And the court said that was not clearly a condition precedent. While it might be helpful, it wasn't itself clear that there was a condition precedent. The typical requirements are either to use the words condition precedent or words such as provided or as that. And here it said it wasn't the case. It also said in interpreting that there was no reason why it should be a condition precedent to payment, that certain information was provided with the application. So while not determinative, it certainly influenced the court in considering what the purpose of the condition precedent was. And this might become relevant when we see certain condition precedents in clauses in terms such as to have a default payment notice, you must say it's a default payment notice and you must write it in size 72 font and in red flashing lights and things. The court might start to say, well, look, there's no real purpose to that and you're just trying to throw obstacles in a party's way. So something to consider as this case sort of makes its way through and gets considered again in the future. The third point was estoppel by convention, and this was a defence from 3CL. So they said, well, look, all 18 of our previous applications on this job were in exactly the same format. We provided the same information. So even if there was a condition precedent to require certain information, Lidl must have waived it because 18 times previously they'd allowed it, and it's only this one which is in dispute. They're raising the issues. And the court said, yeah, that's pretty much right. If we hadn't found that there wasn't a condition precedent in the first place, the fact that Lidl hadn't raised it 18 times previously meant they couldn't rely on it now. So I suppose the lesson here is that if you've got a clause in your contract, you need to enforce it consistently and rigorously, because if you fail to do so when you want to rely on it in the future, the court might well say you can't. And the final one is, again, quite a common amendment or feature of bespoke terms is to link the final date of payment to the issue of a VAT invoice or an invoice by the subcontractor or the party that's being paid. And the court said that you cannot do that. And it drew a distinction between setting the due date, where it said the Construction Act allows the parties a fair degree of latitude in that, provided there is an adequate mechanism, and the final date of payment where there is no such latitude. So the final date payment must be linked to the due date and can't be a variable feast. So all those contracts out there which do try and link the final date payment to an invoice are likely to be invalid, which means that the scheme rules will apply in their place. So if you've got a contract like that out there, do have a careful think about what the final date payment actually is, because you may find it's much sooner than you're expecting if the scheme applies, which is typically 17 days from the due date. And if the scheme applies, that will also affect the date for your payless notices and such like. So if you've got a contract out there which seeks to have invoices as the relevant date, make sure you check them now, because all these smash and grab adjudications could be lining themselves up against you. Adjudication and insolvency. So this has been a common theme for a number of years about whether insolvent companies can adjudicate. And the answer is yes, they can. Bresco and Lonsdale was a Supreme Court decision from a few years ago, which said in principle, there is no fetter on the right to adjudicate at any time, including if the company is in in administration or in liquidation. So an insolvent party can adjudicate. But there was a heavy caveat on that in the Supreme Court decision, which said that while there was an in-principle right to do so, it would leave the question of enforcement up to the TCC and to decide its own rules and whether it was right that an insolvent party could enforce the decision. So there's no doubt that an adjudication can be commenced. The question really is about whether, having got an award in their favour, that insolvent company can actually enforce it. Now, there's a case, Lonsdale, from a couple of years ago, which started to say probably not. You need to have good security in place. You need to be able to, where there is a genuine cross-claim by the other party, the solvent party, the insolvent party needs to have adequate security for that party's costs, because otherwise there's a risk that on paying the insolvent company, that money goes into the general pot, pays out creditors, and is never seen again, so that the genuine cross-claim can't be pursued. So what exact security is required is left up to the parties in any particular case, but typically they expect to see some sort of after the event insurance policy or ring fencing of funds. The case from this year on the slide, J. Bull and St. Philip's Homes, actually went even further and said, well, first, this rule applies to companies that are in administration as well as liquidation, the Lonsdale case referring to liquidation only. And second, that actually ring fencing funds in itself is probably not likely to be good enough security, because the whole point of adjudication is that cash should move and cash should be available to the industry. Whereas putting it in a ring fence fund for potentially 2 years while court proceedings are pursued is not really consistent with the idea of adjudication, pay now, argue later. So that was put into question. And secondly, the security that was offered by the administrators of J.A. Bull was found to be insufficient. The court said that proper security needed to be given for the costs of pursuing a potential counterclaim, and in this case, it was not sufficient. So this is really probably another nail in the coffin for the idea that insolvent companies can actually adjudicate with any real value. Yes, they can adjudicate, but when it comes to enforcing, which is the important part, because otherwise you've just got a piece of paper with a decision in your favour, it's going to be extremely difficult for insolvent companies to do that. If you're faced with a adjudication from an insolvent company, you need to decide quite early on what the strategy is. If you've got a genuine cross-claim, then you may want to consider not taking part in the adjudication at all, certainly reserving all your rights, and then considering what's going to happen at the enforcement stage. Obviously, if you have got a debt that there's no cross-claim against, then the situation is different. But generally speaking, if you've got an adjudication by an insolvent party, you need to think very carefully early on about how you want to proceed. Termination. So a very quick look at this case. So this case was from earlier this year, and looked at the JCT termination provisions. I'm just going to remind myself of the case name. Bear with me. So it's Providence Building Services and Hexagon Housing Association. So in this case, Hexagon failed to make payments due to Providence by the file date of payments, which allowed the contractor to serve a notice under clause 8.9.1. These are the JCT standard D&B termination provisions. The payment was then made, which meant that the default notice fell away. Clause 8.9.3 allows clause 8.9.4 allows, if a specified default is repeated within 28 days, the contractor can then terminate again without serving a new notice. And that's what, in this case, Providence did. However, Hexagon argued that because they had paid the initial default payment within the 28 days, the right under clause 8.93 to terminate had fallen away, and therefore there was no right to serve a new notice under 8.9.4. All quite technical, and the court ultimately agreed with the employer in this case that the contractor had got it wrong. And therefore the contractor was in repudiatory breach when it purported to terminate. It's quite unusual to have a termination on these grounds. To be honest, it's usually the other way around. So it's usually the employer terminating the contractor for a failure to proceed regularly and diligently and that kind of thing. But this really just serves as another reminder to make sure that if you're looking at termination, you've got to make sure things are absolutely spot on, because not only are the provisions frequently very complicated, getting it wrong can usually lead to a claim against yourselves. And finally, my final slide, JCT 2024. So This is the kids at Christmas, which all construction lawyers will be when the thing finally gets published in the spring next year. What to expect, we don't really know yet, but as Andrew mentioned earlier, we've got a fair idea of some things. This is just a flavour. I'm sure there'll be lots when we get the forms, as I say, expected to be in spring next year, but we're not quite sure. There will be provisions which deal with the Building Safety Act updates, and we understand that that's why there is a slight delay in getting the final forms out, because the government is still trying to get the various regulations in place and guidance which will impact on what the amendments need to say. But some of the other issues which might come up, there's going to be a new relevant event to cover epidemics, as Andrew mentioned. And also there's going to be the concept of optional loss and expense clauses. So at the moment, you either get a relevant event or a relevant matter. There will be some relevant matters which parties can choose to apply or not, which will then link back to relevant events. So potentially making the idea of what gives you time, what gives you money as well, slightly more customizable depending on your contract. There's going to be a change from statutory undertakers to statutory providers, which is interesting. We've seen a lot of disputes about that in recent years, about who is and who isn't a statutory undertaker as defined in the JCT terms. EOTs are going to have to be dealt with within 8 weeks rather than 12 weeks. Although that's not really going to make a huge amount of difference because parties should already be doing it as soon as reasonably practicable. There'll be a new due date following the termination provisions because at the moment the JCT provisions don't strictly comply with the Construction Act. There's going to be a clarification on LLDs post-termination, which follows recent cases in the Supreme Court about that. And that's going to expected to confirm that LLDs run up to the date of termination, but not beyond. Once termination has taken place, it will be general damages. Also, some modern amendments like things that go gender neutral. We're going to allow for DocuSign, those kind of electronic execution, and an encouragement for digital working, and lots more, I'm sure. So once it comes out, I'm sure we'll be sitting at this desk again doing a webinar on JCT 2024. And over to Andrew with, is it the final hat of the day?
The final hat. Can't know if I get my little bobble to set up or not. Right. Defective Premises Act. This links back to the Building Safety Act. What the Defective Premises Act was, it came out in 1972, and it was introduced to allow a leaseholder typically to bring a claim against a developer or a builder or an architect in the event their flat it typically was unfit for habitation. You didn't need a contract between the relevant parties. It was a claim in tort, but it was a tricky piece of legislation. And to be honest, you've probably only ever seen it referred to in JCT in one of the clauses. It had a 6-year liability period. And the main issue was that to argue something was unfit for habitation was quite difficult. You know, the flat has to be really bad to be unfit to live in. What has the Building Safety Act done? Well, effectively, it has made it clear that if you live in a flat with defective cladding, that is in itself unfit for habitation because it could burn down too quickly, effectively. So that has made that much easier. What it's also done is changed the 6-year period to 30 years. So any flat built after 1994 can now bring a claim, potentially, 1993, I suppose, but 1994, under the Defective Premises Act. All that said and done, I've referred to the developer's pledge already, which hopefully will result in a number of these flats being fixed anyway. And also it's quite difficult for an individual leaseholder to bring a claim against a developer, a contractor, an architect, assuming any of those still exist from when it was built. So whilst it has changed the landscape, and no doubt will over the next few years result in a number of legal cases, you know, quite how many cases will be run through the Defective Premises Act is still to be seen. A bit more on the Building Safety Act. For those of you involved in building higher risk buildings, you'll know about gateways. The gateways are basically the steps you have to go through in order to sort of go to each next stage. So gateway 1, when you go into planning, you have to put in certain information. Gateway 2 is you can't do certain things. Gateway 2, you have to pass gateway 2 before you can start building. And gateway 3, you can't occupy a building until you've done certain things. Gateway 1 was introduced in August 2021. It's been going for some time, introduced actually not as part of the Building Safety Act, but as part of the planning legislation. And that just requires you to put certain information in at the planning stage. Gateway 2 has now been clarified. So Gateway 2 started on the 1st of October 2023 with a transitional period till the 6th of April 2024. So if you had issued an initial notice and if you have sufficiently progressed by the 1st of April, because it has to be 5 days before the 6th, then you can rely on the old regulations and you're not therefore bound by Gateway 2 and 3. Anything that effectively starts after the 6th of April 2024 is bound by the new regulation. Gateway 3 is the point at which you've finished the job and it becomes occupied. Now, under the old regulations, you'd go to your normal building control officer and they'd sign it off. Under the new regulations, you have to go through the regulator. It's a much more onerous task, and the regulator has 8 weeks to decide whether you've achieved sign-off. That means every job reaches PC and potentially sits there for 8 weeks with nothing happening. So if you are not sufficiently progressed before April 2024, you will be caught by Gateway 3. So what we've learned is the actual dates for these gateways, and we now have some clarity. If you look at the legislation, there are 14 examples given as to whether you do or don't pass Gateway 2. Perhaps an example of how complicated it is. Nearly there, 2 to go. BTS to BTR and to co-living. I'm down with the kids, so I know that BTS is a Korean K-pop band who did once do a single with Coldplay, I think, which is why I've heard of them. And BTS is build to sell and BTR is built to rent. And we've seen a shift in the market. We work for a number of developers, and there's been a shift from build to sell to build to rent. That's partly because there's an uncertain housing market. Certainly on the sales side, there's a very positive rental market, and it allows a positive exit for the developer. So there is a shift, has been in 2023 and probably will be again in 2024. And what connects to that is co-living. Co-living is a sort of effectively a rental option which is used typically in expensive areas. It's very expensive to buy a flat in London, for example, but if you can get a slightly cheaper flat with a number of the amenities dealt with in common parts, it also suits younger people's living. We're seeing an increase in co-living. It's a way of meeting housing demand. It's very much an option for high expensive areas and has total flexibility and does allow the developer an exit. So is that the future for next year? We expect there to be a number of co-living schemes next year. The final one is number 24. Now, I have to apologise. I've been trying to download the 12 Days of Christmas music, but I can't get it to work, so I'm going to do it a cappella. We're going to finish, obviously, with 2 new solicitors. So the way it goes is, on the 12th day of Christmas, my true love gave to me. We're going to change that to, on the 12th day of Christmas, the construction industry was 12 months of chaos, 11 or more pieces of legislation associated with the Building Safety Act, 10 large insolvencies in the year, 9 jobs of trade contracts that we've had at least during our year, 8, the number of the Archor office, 7, the number of TCC court cases that we've been involved with, 6, the number of partners in Archer, 5 additions of aggregate, or at least I think so because I haven't checked, 4 training solicitors in the office, 3 Archer babies, that's 2 children, 1 with Hannah, 1 with Ruth, and 1 grandchild, which is mine, and 2 new solicitors, Lucy Day and Sophie Bennett, and 1 old partner in a pear tree. That is the end. Most of you, but a lot of you didn't go off of that.
No, the numbers stayed up. I thought there might be a deluge of people leaving as that song got underway, but
I'm going to get off that. So thank you very much for that. I'm a natural singer. I'm annoying enough as it is, but if I could actually sing, I'd be horrendous. Thanks for that. All have a lovely Christmas. Thanks for joining us. And we'll say goodbye.
thank you very much.